5360, Joey Peterman versus Mengan Zhu. Council, make your appearances.
Melissa Hatcher for the defendant, Mengan Zhu.
Maria Aceves here as the guardian ad litem for minor AP.
All right, go ahead and call your first witness. Oh, and go ahead and have Ms. Peterman introduce herself as well as her daughter.
Yes, my name is Joey Peterman. I'm Ashlyn Peterman's mom.
All right, let's go ahead and call our first witness.
Your Honor, at this time, I would like to call Ms. Peterman.
Ms. Peterman, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let's proceed.
Please state your name for the record.
Joey Peterman.
Ms. Peterman, my name is Maria Marifeta Aceves, and I am the guardian ad litem in this matter. I was appointed by the court to represent the interests of your daughter, AP. Do you understand who I am and who I represent?
Yes.
Okay, and just for clarification purposes, since we are live on YouTube, if you could please refer to your daughter as AP throughout this proceeding.
Okay.
You are the natural parent, guardian, and next friend of minor AP, correct?
Yes.
And you brought the suit on her behalf?
Yes, ma'am.
And you brought this suit pro se, correct?
Yes.
And just for clarification purposes, you do not have an attorney representing you per se?
No, ma'am.
Okay. Now, you and I had a chance to meet via video conference before today, is that right?
Yes.
And I actually had an opportunity to speak with both you and AP.
That is correct.
And in that meeting, we discussed the accident, AP's injuries, and how she's doing today, among other things.
That is correct.
Okay, and you understand that we're here about the accident that occurred on February 6, 2019?
Yes, ma'am.
Could you briefly explain to the court what happened in that accident?
In my words or in AP's words?
In AP's words, fine.
Okay, you want to? I'll speak on her behalf. She was driving on a local street in Coppell, was proceeding, I don't even know what direction it was straight, and there was another car that was in a turn lane to make a left turn, was supposed to be a protected green arrow, but unfortunately they pulled out as she was proceeding through an intersection, her having the green light, and she tried to stop and to avoid him and was not successful with that. So they collided.
Sure. And did AP suffer any injuries as a result of the accident?
We did go that evening to the emergency room because she was complaining of abdominal pain. Of course, she had some from her seatbelt where she was caught, just some basic bruising, thankfully, but they did do a CT scan and such, and there was some swelling, but no internal injuries at the time. It was just more stiffness and soreness from the accident itself.
Sure. And did AP receive any additional treatment?
Just that evening at the initial ER visit.
Okay. And it's my understanding that AP also later, approximately 3 weeks later, suffered an anxiety attack. Is that right?
Yes, she was pretty shaken up from the accident, of course. Didn't drive for several weeks, and it was one of the first times that you were driving, actually driving to school for the first time after the accident. Was proceeding to school and saw a similar scenario where someone was turning left in front of her. She started to panic because it was kind of like a flashback to the accident, got very anxious, proceeded to school, went straight to her nurse's office, and they, tried to calm her down and such, but her heart rate was so elevated that they notified me at my office saying that they felt concerned enough to call an ambulance for her, and she was then taken down to Parkland for evaluation because her heart rate was so high.
Okay. And then she was also diagnosed with a heart condition called Wolff-Parkinson-White syndrome. Is that right?
That is correct.
Okay. And she was also referred out to a cardiologist at Children's. Is that right?
Correct.
Okay, and the cardiologist at Children's recommended that she undergo a heart ablation. Is that right?
Yes,
Okay.
which happened the end of May of that same year.
Now, how is AP doing today?
She's doing quite well, doing very good.
As a result of this accident, did AP incur medical expenses for her injuries?
She did. Just the follow-up visits, the expenses for the anesthesiologist and the treatments and the procedures themselves post-accident.
And of the medical bills that I received and I reviewed, it looks like Optum paid approximately $2,273.04 on behalf of AP.
That is correct.
Okay. And it looks like you paid approximately $5,152.14 out of pocket for AP's medical expenses.
That's right.
Now, you understand we're here asking the court to approve a settlement resulting from the accident, correct?
Yes, ma'am.
And you understand that the defendant has offered to settle this matter for his policy limits of $30,001.
Yes, ma'am.
And after paying the medical expenses, it's your understanding that $22,575.82 will be issued directly to AP when she turns 18.
That is correct.
And sorry, Judge, I think you're muted.
We just discussed about how the PIP 2,500 extra is going to go from the PIP. Can you guys hear me?
Yes, now we can hear you.
I'm
The
sorry,
2,500 that needs to be added into the amount that the minor gets, and then she'll be able to get the 2,500 from PIP.
Okay, one moment. Let me just pull up my calculator and bear with me.
It should be $25,075.82.
Oh, with the, okay. How much did you say it was, Judge? I'm sorry.
$25,075.82 should go to the minor.
Thank you, Judge. Okay, apologies if we could go back. So although you paid the $5,152.14 out of pocket on behalf of AP, it's my understanding that you will only be reimbursed what? Okay. Apologies, Judge. Do you have the amount that would go to mom? I'm trying to do the calculations right now.
The amount that would go to mom right now would be $26.52.
Clearly, math is not my strong suit. Okay, apologies. So out of the $5,152.14 that you paid out of pocket, it's your understanding that you will only be receiving $2,652.14. Is that correct?
Yes.
And it's your understanding that you will also be making a PIP claim with your own insurance company for $2,500. Is that right?
Yes, per the judge request. Sure.
Correct. Okay, so after all of those expenses, is it your understanding that $25,075.82 will be going to AP in this matter?
Yes, ma'am.
Okay, and it's my understanding that the parties have agreed that those funds will be issued directly to AP once she turns 18 and after AP signs off on the settlement agreement.
That is correct.
And I assume the check will be made out to AP, correct?
Yes.
Yes, Your Honor.
Yes, Judge. Now, you and I spoke about placing those funds into a structured annuity for AP, correct?
Yes.
However, due to the current circumstances and AP's age, it is my understanding that the preference is for those funds to go directly to AP when she turns 18.
I would prefer that so that she has that control.
Sure. And it's my understanding that we had discussed AP using those funds to pay for her tuition.
That is correct.
Okay. And you understand that those will be AP's funds to use for AP's benefit.
Oh, yes.
Now you understand that this is also a final settlement?
Yes, ma'am.
Okay. And are you asking the court to approve AP settlement because you believe the settlement is in the best interest of your child, AP?
Yes, ma'am.
Your Honor, at this time, I pass the witness.
Okay. Any other questions?
Just briefly, Your Honor. Ms. Peterson, do you understand that by accepting this settlement, you're waiving your right and AP's right to a jury trial?
Yes, ma'am.
And do you understand that a jury could have awarded more, less, or the same for the settlement?
Yes, ma'am.
And you understand that this is a full and final settlement and that it includes any reimbursement for injuries or bills incurred for injuries that are known or unknown at this time?
Yes, ma'am.
And if I were to ask you all of the questions that the guardian ad litem just asked you, would you answer them in the same way?
Yes.
Thank you, ma'am. No further questions.
All right, Ms. Peterman, do you have any questions for me?
Not at this time, sir.
Okay. And then if you could have your daughter just introduce herself.
Would you like me to use my name or just refer to myself as AP?
That's a really good question, actually. We're using AP as kind of a way to protect you because under the open courts provision of the Texas Constitution, we're going to be posting this on YouTube. I don't know anything about we're not going to be putting your name in terms of, it's not going to be on the YouTube screen. It's just going to say it's my docket. But if you feel okay with using your own name, you're almost 18, you can do that. Or if you would prefer to just continue to be AP, but it's really just for your protection. And I think the thought process is that if you have friends out there that may not be looking out for your best interest and they find out you're about to get all this money, we don't want them to come to you and say, hey, we want a bit of that money that you know what I mean? Does that make sense?
Yeah. Yes, sir.
So I know it seems silly, and if I were you, I would think this seems kind of crazy that I'm calling myself AP, but that's why is we're just trying to protect you.
I understand.
Okay, so I'm not trying to be hard on you or anything, but I just want you to just.
No, thank you.
The reason we're doing it, there's a reason we're doing it. All of this is to try to make sure that this settlement is in your best interest and this money goes to you because you were the one injured in this case. And so we're doing everything we can to protect you. So, all right, did you hear your mom's, the discussion I had with your mom and your mom's testimony in this case?
Yes, sir.
Do you have any questions whatsoever?
No, sir.
And you understand this is your money. I hope you use it for college, but it's your money.
Yes, sir.
It sounds like your mom understands that, which is great. And do you have any other questions? Do you understand the thing about the PIP, how your mom's going to get reimbursed for a portion of the money that she spent from her own insurance company?
Yes, sir.
Okay. One other thing I did want to talk to you about, and this was kind of at Ms. Hatcher's request, but I think it's a good point, is that you potentially could make an additional claim here when you turn 18 against your parents' uninsured motorist coverage. There's pluses and minuses to that. I don't know that I would necessarily suggest that without doing that without an attorney. And I'm not recommending, I'm not making the settlement contingent on that. But for example, if you have long-term health issues related to this accident dealing with your heart, you might want to look at making a claim on the underinsured motorist coverage. That's what the coverage is for. Your carrier will have a $30,000 offset, which will make this claim harder. But I do want you to know that you have that opportunity and right. And I'm sure Mrs. Savis has already kind of mentioned that to you.
Yes.
Okay. Do you have any questions about that?
No.
Okay. Is there any other questions from anyone in the family, the Peterman family?
No, not at this time. I'll definitely look into the PIP claim and go from there. That shouldn't be a problem.
Okay. All right. Mrs. Davis, do you have a report?
I do, Judge. Your Honor, at this time, as the guardian ad litem, I am of the opinion that the settlement offer of $30,001 that has been extended to AP by the defendant is reasonable to compensate her for her injuries. I do believe the settlement is in the best interest of AP, and I would respectfully request that the court approve the settlement at this time.
You know, and I was looking through my past emails. I thought that I'd seen your email with all of this information in it, but I couldn't find it. And maybe it went to my spam or something. I just couldn't find it. But what is the amount of attorney's fees? I was looking at another prove up that I was thinking of, so I may not have gotten this one. Do you have an agreement as the amount of the guardian ad litem fees?
So I actually have been communicating with defense counsel, and since we will need to submit an updated final judgment with the court's ruling, I'm also going to be submitting an updated proposed order approving the guardian ad litem fees.
So what amount is the fees?
Currently, they are at $1,875, which includes 12.5 hours billed at an hourly rate of $150 an hour.
Can we just make it around 2,000 for the extra work?
Yes, Judge, that's perfectly fine with me if that's okay with the opposing counsel.
Ms. Hatcher?
No objections at all, Your Honor.
Okay, that's actually remarkably, considering the case, remarkably cheap. Ms. Peterman, just so you understand what's going on, this $2,000 is not going to be by you or your daughter. That money is going to be paid by the insurance carrier, and they're going to pay Ms. Aceves directly. So I don't want you to worry that that money is going to have to be paid by you or your daughter, okay?
Thank you, Judge.
All right. Anything else? So go ahead and e-file and email to my court coordinator the new judgment and the new order on the guardian ad litem fees. If possible, if you could do that today, that'd be great. Anything else we need to talk about on this case?
Yes, Judge, I will have those documents in today.
All right, thank you so much for your service, Mrs. Davis. As always, we had a hearing recently on another case where the attorneys were saying that you were the best guardian ad litem that ever worked with us. So I think it was Miss Rogers said that, and Hillary Rogers. So you always do a great job, and we really appreciate your hard work on this, okay?
Thank you, Judge. I very much appreciate it.
And Ms. Hatcher, I'm glad you guys were able to work everything out. We're going to go ahead. You guys are now excused, Ms. Peterman, and you may leave as well.
Great. Thank you, sir.
Thank you.
Thank you, guys.
Judge, it was a pleasure working with Ms. Hatcher and Ms. Peterman.
Great. Thank you so much.
Thank you.
Let's go back to Sanchez v. Doe, which is cause number 177604. Have you guys worked everything out now?
Your Honor, we have a few remaining items.
Okay. Let's go back on the record on that case. Is there anything else? Go ahead.
Okay, thank you, Your Honor. With respect to interrogatories, we have remaining interrogatory number 24.
Okay, what's the issue?
We have asked for the plaintiff to identify what any acts or omissions by my client which caused or contributed to the accident in question and alleged damages. The answer given was, where'd it go? The answer given was to see the petition on file. I don't think the petition is sufficient. It's notice pleading. It's not any detail. And as Your Honor may or may not be aware, we have filed a summary judgment with respect to this causes of action against our client. And without the plaintiff's deposition, we still don't really know what the plaintiff alleges that we did. So we would ask the court to.
That objection is overruled. You'll just need to provide an answer to that. What's next?
Next, Your Honor, is request for production number 5. And that request asks for correspondence, evidence, and communications between plaintiff and defendant, or between defendant and any person or party. We have been, where'd it go? The answer given was basically that it's overly burdensome and we have the same or better access to it. We've been given no documents.
So just so it's clear, that's just the plaintiff, not plaintiff's attorney, correct?
Correct.
Just the plaintiff. If it's just the plaintiff, that's for any, and it's correspondence involving this accident, correct? It's not
Correspondence,
all, right?
correspondence and documents evidencing communications between plaintiff and any defendant or between any defendant and any other person. Basically, if they're going to use correspondence against us to either assert we've made an admission or anything else like that, we were asking for copies.
I'm going to overrule the objection to the extent it is requesting information involving this particular accident.
Thank you, Your Honor. The next, I think we have two more. No, one more, Your Honor. Request for production number 26.
Sorry, muted. I've been wanting to talk and wondering why no one is responding. I was like, everyone's ignoring me. Okay, so on number 5 for request for production, to clarify, this is any documents that or correspondence that are directly between the plaintiff and the defendant, not between plaintiff's counsel and defendant or
Correct.
defense.
Correct, absolutely correct.
And then, Your Honor, if I may, now I know why I was not heard previously. On interrogatory number 24, it asks if you contend that there's any act or omission part of defendants that caused or contributed to the occurrence. We do refer to our petition on file and object that this is trying to require us to provide a statement of all available proof. But I think the court needs a little bit of background. We are going to have a hearing on Monday, and the court will become very aware of our lack of information given by defendants. But at this point in time, we still have about 20 defendant witness depositions that we're waiting to get dates on. And we've not even been given Ridgemont's safety manual or the contract between the owner and Ridgemont. So there's a lot of information that we're waiting on to be able to answer these more fully. And that's the big issue here.
And Your Honor, that response strikes me as a bit strange in that means the plaintiff filed a lawsuit without even having knowledge or firm theory of what my client caused, which of course would be a violation of Rule 13. And I don't think counsel's admitting to that.
And of course,
But hang on, Ms. Banish, I'm trying to respond.
Guys, I've ruled on this. Let's move on.
Okay. Your Honor, the only.
And I will say this to Ms. Banish, which is you provide the information you have. And if you don't have all the information, if you're still trying to get this witness, you're still trying to get additional discovery, then you can supplement that as you get additional discovery in. But you do have to provide some kind of basis of what you think they did wrong if they didn't. I don't know anything about it. So what else do we have, guys?
The remaining issue, Your Honor, is request number 26, in which we ask for all documents which support or on which they will rely on support for the claims that caused the claims in this lawsuit and the occurrence based in question. Basically, it's the request for production copy of interrogatory 24.
That is too broad. I'm going to go ahead and sustain the objection to that. All right. Anything else, guys?
Nothing from defendant, Your Honor.
thank you, Your Honor.
Thank you, guys. You guys be safe, and we'll just give me an order to that effect. Make sure you clear it with Ms. Banish and try to get that to me as soon as you can.
Okay, and Your Honor, well, I'll deal with it on Monday. Thank you, Your Honor.
We'll see you on Monday.
Bye-bye.
All right. Bye. Do we have anyone here on cause number 1817613?
Yes, Your Honor.
Both
Susanna
sides here?
Yes, Your Honor, this is Doug Hubel on behalf of the plaintiff.
Susanna Kepler for the defendant.
All right. Do you guys want to go ahead and get started with this?
Sure, Your Honor, I guess I'm a bit confused as to why we're here. We were set for trial next Tuesday. Today was the time at which we were to announce, but we were told by the court that we wanted to discuss, I guess, how we want to handle this going forward.
Right. So this is the issue, as I mean, you guys, I'm sure, are aware. we're not having jury trials next week. There aren't any jury trials really in any state court at this point, although they're beginning to do this on federal courts. And, things are very much up in the air depending on what happens with this pandemic. But a couple of issues we're trying to talk to everyone about is just, hey, one thing that would be helpful is if we could do 6-person juries. It would allow us to be able to try the case in our courtroom. We could do jury selection in our courtroom. If we're going to have to do 12-person juries, then we're going to have to find another location for sure to do jury selection, but also possibly try the case. And so what I am proposing to the other judges, and we're still kind of debating this, is that for my 6-person juries, those would start on Tuesday, and then I would hopefully get those tried. For my other trials, I would pick one day a month where I bring all of the cases where people are not willing to do a 6-person jury and select the juries back to back in the central jury room, kind of like they do in the smaller counties. I will say this, that I've had a number of attorneys say, well, I need to talk to my client, or I prefer 12-person juries. This is a time of pandemic. 12-person juries are far more dangerous to other jurors, to the staff, to the attorneys. And so I would highly, highly, highly recommend that you try to agree to a 6-person jury so we can try to get this case tried in a safe way. What are your thoughts on that, Mr. Hubel?
I have no objection to that. I don't believe we requested a jury, so I have no objection to that.
Ms. Kepler?
Yes, no objections here either, Judge. I will say that also would like to let you know that we would like, I believe we're going to be withdrawing from the case. There was a DAC action judgment recently, and it is our understanding that we will no longer be compensated by the defendant to be representing the defendant. So unless we are able to reach some kind of agreement with the defendant, we're going to be filing a motion to withdraw.
Mr. Hubel, are you aware of this?
Yes, I've been in contact with Mrs. Klepper's office and was copied on the DEC action that she speaks of.
And whose court is that in?
I can provide this to you right now, Your Honor. Bear with me. We were not obviously the ones on the DAC action, but we were given a copy of the judgment recently. And this was the 14th district.
Mr. Hubel, if you want to have that case transferred to me, I'd be glad to look at that and figure, unless it's, I don't know if it's too late to overturn that or if it's a final judgment or what, but typically when you have this type of situation, I like to if I'm handling the liability case, I'd want to handle the DEC action as well. So if you want to see about transferring that to my court, I can look at that, but because I think it's a related case.
Sure, I guess, and I guess my thought on that was that I represent State Farm. State Farm obviously was not a part. Well, State Farm was not a party to that case. I guess I never thought that I would have standing to transfer a case in which I wasn't involved in. My client wasn't involved in to your court.
Yeah, that's a good point. Usually that's not how it works. You could also try to consolidate it, move to consolidate the case. But anyway, you don't have to do it. I'm just, if you want to, I've done that before where I've either transferred or consolidated the case. So you have the coverage issues and the liability issues all in the same case. But so let's do this. Tony, let's go on the record real quick. The parties have agreed to a 6-person jury. Rhonda, are you there? Do I see that? Rhonda, make sure you put this in our notes, but and in the notes for the file. Let's go on the record on cause number DC 1817613, State Farm Mutual Auto Insurance versus Valenzuela. Counsel, make your appearances.
This is Doug Hubel on behalf of the plaintiff, State Farm.
Susanna Kepler on behalf of the defendant, Ms. Valenzuela.
All right, the parties have agreed to a 6-person jury, and the court is going to grant the continuance. We're going to reset this case to November. So Does anyone have a problem with November?
November's fine with planning, Your Honor.
Works for us too as well. Thank you.
Rhonda, just go ahead and set it to November. Anything else we need to chat about?
I was under the impression that the motion to withdraw had been filed. Is that not right, Ms. Kepler?
I don't believe that has been filed yet. I know my paralegal is working on it. If she hasn't filed it, it's coming. So,
I guess my only request would be that we set that for hearing as soon as possible so that I understand, a better understanding as to who I need to be dealing with.
certainly.
Sounds good. All right, thank you so much, guys.
All right, thank you, Your Honor.
Thank you, Your Honor.
You guys are excused.
Thank you.
Okay, does anyone have any questions about any of the hearings today?
We're still on YouTube.
Oh, oops, good, thank you.